right, good morning, everyone. We are so pleased to be here to have the Tennessee Court of Criminal Appeals here at the University of Tennessee at Chattanooga. There are a lot of people I want to thank, but first I'm going to introduce our panel. Can y'all hear me okay? All right, to my right is your local celebrity, Judge Tom Greenholtz, very proud UTC alum and a great member of our court, obviously here from Hamilton County. On my left is Judge Kyle Hickson, who's from Knoxville. And all three of us were trial judges before we came onto the Court of Criminal Appeals. And as I said yesterday, I realized we were all three UT law grads. So we are so happy to be here. And I'm Jill Ayers. I'm from Clarksville, Montgomery County, Tennessee. And so I'm from the middle. These two guys are from the east. Our court kind of rotates around, and that's one of the benefits of the Court of Criminal Appeals. So there's so many people here that we want to thank today, and I hope I don't miss anybody. First of all, we're just thrilled to be in this beautiful location. If y'all get bored listening to us or the lawyers, you've got a fantastic view behind us. We're used to being in a courtroom with no windows, so this is truly and absolutely a pleasure. So we really want to thank the leadership of UTC, including Chancellor Stephen Angle, all the administration and the staff who have made this possible. Brett Fuchs, Lieutenant Nathan Hartwig, UTC Police Department, including Chief Sean O'Brien, and then also the library leadership, which includes Nora Catron, Bo Baker, Michael Andrews, and Dr. Deerdorf. So there takes really a team to put all this together, and their commitment to this process has really made this possible. We've got a lot of folks who've traveled with us, with whom we could not do this without their involvement. And that includes all of our court staff from the AOC, doing our live stream, Jim Hivner, our clerk, and all of his staff, and the staff from the Knoxville clerk's office, as well as Judge Greenholt's law clerks, who have been really helpful in this process. And then finally, to the students who are here today, we want to thank you. I don't know, maybe you had an option, maybe you didn't if it's class credit, but you're here, and we appreciate that you are here, and we appreciate your interest in this process. Hopefully, getting to watch this up close and firsthand will give you a better understanding of the law and the application. I'll go over this again later after we complete the arguments in each case. We're going to take a recess, and the attorneys are going to stay around, and students will have the opportunity to ask questions of the attorneys about the case. We can't discuss the case, so that's why we're going to excuse ourselves for that part of the process. Did I forget anybody? Okay, awesome. So again, we're just so happy to be here. We'll get on with the process. As each side knows, you have 20 minutes per side. If the appellant wants to reserve any rebuttal time, let us know on the front end. Thanks to the Knoxville Clerk's Office, we've got our timer here, so that will help you keep up with that. And are there any preliminary matters? No. All right, then if you'll call the first case, Mr. Hivner.
State of Tennessee versus Billy Norman Forte.
Good morning, Your Honor. Today is Lord William Neal on behalf of the appellant, Billy Forte. We're supposed to finish the count was 4 minutes to rebuttal. As a preliminary note, the court, consistent with the briefing, I will refer to my client, the appellant, as Mr. Forte, and will refer to him as Charles. I do so simply to avoid confusion because I think she is the same last name. Your Honors, it's undisputed in this case that Mr. Forte shot and killed his son, Charles Forte, on a day question at East Formal Ware, which was a business operated by Mr. Forte. That is not in dispute. That was not in dispute at trial level. What is very much in dispute in this case is the mental state of Mr. Forte. The most important action in this case, legally, was what was going on inside Mr. Forte's head during the decisive moments. Mr. Forte's mental state was critical to his claim of self-defense, which hinged upon credibility of his testimony and his statement to law enforcement. that he had seen Charles reaching for a gun, or believed that he saw Charles reaching for his gun before the killing. His mental state was also critical to the homicide offenses that were charged against him. Both the charged offense of first-degree murder and all the lesser-included offenses. Those were primarily distinguished by the mental state of Mr. Forte. And Mr. Forte's mental state is also critical to the issues raised with him. As you're all aware, we have raised 3 issues in the field. I will be primarily focusing on the first issue pertaining to the state's failure to preserve the 911 call, as well as the second issue pertaining to the introduction of Mr. Forte's prior conviction for domestic assault. I'm, of course, happy to answer questions that I can answer this as well. Turning to that first issue, the state reached its duty to preserve potentially exculpatory evidence in this case when it destroyed the recording of the 911 call. The trial court appropriately found that there was a violation of Mr. Forte's right to due process under the Tennessee Constitution based upon that state's evidence. The problem, however, is that because of the nature of this failure to preserve evidence, a more consequential remedy was required than jury instruction that was given by trial.
So, counsel, we're talking about the evidence that's at issue here is his 911 phone call. Is that correct?
Correct, Your Honor. There were 2 911 calls placed in this case. One was by Mr. Pearson, who was in the room.
And the other was by
The
your
other was
client.
by Mr. Forte. His call was first.
So your friend on the other side suggests that even if there had been a negligent failure to preserve his 911 phone call, that among other things, there was good substitute evidence of what happened in that phone call, not least of which was your client's statement to law enforcement authorities that occurred shortly thereafter. What is it about the nature of the phone call itself could not be remedied with the defendant's own statement to law enforcement made shortly thereafter?
That raises a few points. Number one, it is true that when law enforcement arrived on the scene shortly after Mr. Forte placed the call, one of the arresting officers asked Mr. Forte something to the effect of a violation. Mr. Forte attempted to start to explain. He did not get one sentence out before the officer told him to, quote, shut up.
But there was a second statement, a longer statement given by your client. Isn't that right?
Correct, Your Honor, that did not occur until much later. And so there was an initial statement at the scene, which was foreclosed, shall we say, by the officer. And I don't mean to critical the officer, he was trying to secure the scene and so forth. But we cannot say that Mr. Forte was given an opportunity to make a statement when he was told to shut up.
So is the value in the 911 phone call, is that limited to, this is happening immediately after the shooting, I'm telling my version of events immediately after the shooting, is that the value of the 911 phone call?
Your Honor, it's not just that he's telling his version of events. This court held in the State versus Nicholas Johnson FW case that the best evidence of the defendant's state of mind following the killing is a recorded statement he made immediately after that killing. And as you get more remote in time, the value diminishes.
Okay, so how much further remote in time was the longer statement that the defendant gave to law enforcement?
Several hours.
Okay, still the same day?
Yes, Your Honor. Later that night, I'm not sure if midnight passed.
Sure. What was he not able to communicate to law enforcement that would have been in the 911 phone call?
Well, what you don't get from a longer statement later on is what is in the nature of the type of evidence. Because what this court tells you, the reason it's the best evidence is because you get the demeanor. You get the closest you can get in a case like this to a window into the mind of someone, the kind of feeling when you can hear a recording of it right now.
Okay, so the defendant testified at trial. Was he not able to communicate that to the jury, what his demeanor was at the time, what he was thinking, what the circumstances were? What else would the 911 phone call have added to his testimony at trial?
What we would say, Your Honor, is that him describing the 911 phone call, and first of all, his memory at this point was many years later, so we'll know that memory of that call was in the report. Mr. Forte had suffered a stroke a week before he did this case, and so a lot of factors go into that. And the most important thing, though, is that his description to the jury during his testimony many years later is simply not the same.
The value of the 911 phone call, really, when we boil it all down, it's just corroborative evidence. New substantively is not adding anything new by way of description of events that couldn't be solved in the initial statement to law enforcement officers an hour later, his trial testimony. It simply is there to corroborate what he's telling the jury. Is that really what
Well, not even just to corroborate, but rather to help resolve his state of mind, which is something that was a matter of circumstantial evidence. And the evidence on that was very ambiguous. The person who was in the room, Ms. Pearson, I hesitate to call her an eyewitness because she's not looking at me. So we have a situation where we're just looking at conclusive, imperfect, circumstantial evidence about Mr. Forte's state of mind. Again, this court has held that best evidence is a recording of a defendant in the immediate aftermath of the killing, and the jury was deprived of best evidence.
So he's entitled to a fair trial, not a perfect one, right? Why is it that dismissal would be the preferred remedy here when there is other evidence of his intent? When there is other evidence of what he observed, when there is other evidence of what he believed? Why would dismissal be the remedy rather than the jury instruction of the trial court?
Well, Mr. Cullen has a response to that. First, and this goes to something you mentioned earlier, that the state was able to put on substitute evidence. The state was able to put on evidence that Ms. Pearson walks out of the room because she was scared, and she walked back into the room to retrieve her cell phone. This says something about addition of cell phones that I won't go into. But she heard the last part of his phone call. She was able to testify. The state was also able to put in notes from that phone call. Very cursory notes to make sure that the computer was dispatched. The problem is the state was able to put in which was that Mr. Pearson was a communication. Instead of providing the jury of evidence that potentially substantive evidence, that became a statement. And in terms of the we do maintain that trial all three of the factors. They weigh very much. The dismissal was appropriate. However, Your Honor, I think that State versus Clifford Clark, which is the case before decided in 2011, that case is discussed in a briefing. We had a similar situation with the State and failed to observe physical evidence. And then the State wanted more favorable substitute evidence. And what the court said was...
What was the evidence at issue in that case?
In that case, it was a vandalism case, and so the state had failed to preserve physical evidence and had to vandalize.
Okay.
I believe it was a traffic light.
So we're not talking about a failure to preserve a defendant's statement when the defendant gives another statement hours later and is testifying at trial.
Not exactly that, Your Honor, but similar in the analogous we submit in the sense that the state was able to submit a more favorable substitute evidence. And what this court held with that is that the tool is not required for the jury instruction to find out. And so what they held was that the appropriate within the state issues more favorable evidence. Exactly what the state did. And so that would provide a good ground for the to decide that a jury instruction is insufficient, that this dismissal would be too much. And for that reason, we would ask the court to consider first dismissal and then the alternative, shall we say, middle ground.
Can we turn to the time frame a little bit? If the evidence was that critical, from what I understand from the record, it was 3 years later. I mean, the 911 call actually existed for a period of 3 years, and yet the defendant never sought to obtain it, and really didn't even I'm not even sure if they even knew it existed or didn't exist. So talk to me about why that's not a problem for your client.
This does get into a little bit of the weeds about how this goes. First of all, although the state may disagree with this, I'm not sure it's entirely clear that the person did that in the usual course of proceedings. This is turned over to himself. That is how this goes typically.
But even if that's the case, how did they not know they didn't have it?
I mean, it's subject to an Open Records Act request, right? I mean, it's here in Hamilton County.
I get into this too much, but
Yeah.
there have been issues in other cases where such a request has been.
Okay. All right.
Especially with videos on crime, there's exceptions that come into play. And so I'll just leave it at that. It's not entirely clear that Mr. Forte would have thought he was on his own.
Did he attempt? Did he make any attempt to do that?
There is no indication in the record of any attempt to do so. But yet, the further trial expectation that the 911 call would be used. And so I believe the way that this occurred was that when he stayed at some point during that period, notified the 911 call center and the agency that would be meeting that, and the call preserved Ms. Pearson's and they were put over into discovery. Not apparent that Mr. Forte's trial counsel was immediately aware that there was another 911 call, but Mr. Forte, who is this court may know, engages in some person advocacy, brought it up. And at that, the issue was so it took some time for that to occur. There may have been some confusion as to whether or why the recording had not been captured. It eventually came out in testimony that the 911 center is called the process for 911 calls. So as you can imagine, a crime involving a gunshot might be any 911 calls. So those calls are supposed to be linked to the system so that they're all preserved for that to happen.
So going back to Judge Ayers' answer, Judge.
Go ahead,
I was
Colin.
just going to ask, when did the state's discovery response, how did that relate to the time of the 3-year instruction period? Was it before or after?
That occurred, the state at least communicated with the 911 center and preserved the other 911 calls during that period. And then its discovery response occurred either just before that or after it expired, such that by the time this was all hashed out, they had already destroyed it.
I was just curious if it had occurred before the destruction or at least before the 3-year period.
And those are the state's initial communication with the 911 center occurred during the 3-year period. That's why they preserved it.
It was probably pretty quick, I would imagine, as it was one call.
Correct. What is it is that it was negligence, because at that point, they were aware that any 911 call in this case related to a pending first-degree murder case. And that demanded more effort to ensure that any evidence related to such a case would be preserved. If you look at this court's decision in State versus Ashley Thomas, the court held that when police had evidence, the law enforcement agency had evidence, and they knew the possible charges were forthcoming, and they allowed the evidence to be destroyed pursuant to their usual policy, but that was gross negligence. And that was based upon the possibility of future charges. Here, we had a pending first-degree murder prosecution, notwithstanding that the recording was destroyed pursuant to the call center's process. Now, my friend points out that there was no deliberate conduct. So it was not somebody in the call center who said, let me go to the records and destroy this so that Mr. Forte would provide favorable evidence. Of course, that would be ridiculous.
So counsel, back to Judge Ayers' question though. She was asking, I think, in terms of the 3 years. When was the request made by defense counsel for this evidence, either pursuant to Rule 16 or otherwise? Is this a situation where defense counsel did not request the 911 phone calls, or did not request that they be preserved, and we're just depending upon the state to turn it over without a request?
I believe they were depending upon the Rule 16 request.
Was a request actually made? Is that in the record? Okay, when was it made in relation to the 3 years?
I'll have to look at the record and verify this. I believe that by the point that, I believe that the request was made. Delay early in the case. Because of that, I believe the request was made after the 3-year period.
Okay, so the first time the defense counsel was making a Rule 16 request, 3 years into the litigation, after the evidence started to destroy.
I will
You're saying it's the state's negligence?
Yes, Your Honor, because the state knew that there was a pending first degree murder case that was going to be litigated.
Ferguson depends upon Rule 16, and we're talking about the duties reserved that arises under Rule 16. Rule 16 is triggered by a request from the defense counsel. If no request is ever made in a 3-year period, how do we even get over the threshold first?
I'll say, Your Honor, given the way that the trial proceedings happened in this case, Mr. Forte's trial counsel did make a timely Rule 16 request. The state was under an obligation to preserve potentially exculpatory evidence during that time period, and that duty extends to law enforcement. It also extends to someone like an agency like a 911 call center. And so for that reason, the Rule 16 request was timely, irrespective of how it was timely based on the rules of Rule 16. And based upon the usual course of proceedings, trial counsel had every reason to expect that it would be preserved. I believe I may be out of time, so I'll just briefly conclude by asking that this court reverse the judgment of the trial court and order the dismissal of this case for the alternative legal case for the trial.
Thank you.
General Coleman? Okay, hold on 1 second. We're going to have a little mic adjustment.
Good morning, Your Honors, and may it please the court. Is this working? Your Honors can hear me, then we'll go from there. Ronald Coleman on behalf of the state. This court should affirm the judgments for 2 reasons. First, to the extent that there was a Ferguson violation, the trial court properly exercised its discretion in determining that the appropriate remedy was a jury instruction. And second, the trial court properly exercised its discretion in making evidentiary rulings. My friend on the other side wasn't able to get into the evidentiary rulings, so unless this court has any questions on those, I'll address the Ferguson claim. But before I do, because we have people in attendance who might not know the facts, I want to do a brief factual background. So on April 2nd, 2018, the defendant shot and killed his son by shooting him with a shotgun in the head. The defendant was charged with first-degree premeditated murder, but was convicted of second-degree murder. The victim, the defendant's son, worked at the defendant's company, and earlier in the day, the defendant had gotten into an argument with the victim. Later that evening, the victim had called a coworker to come to the business to help him out with a computer problem. And a few minutes after that coworker arrived, the defendant came into the room, asked a question, something along the lines of, "Did you end up helping that lady?" or something about a lady. And the victim responded in the negative. The defendant then left the room, acquired the shotgun, and came back in the room before shooting his son in the head. He told police that he shot the victim because of bullying. He said that the victim had, quote, pushed him too far, and that you don't push and bully me. And he even said that the victim made his own bed. And he made several other damning statements during a police interview when the police had stepped outside of how he's going to get the jury hung, and it's a jungle and you take care of things yourself, things along that nature. But later at trial, he insisted that the victim always carried a pistol and that he, the defendant, was simply defending himself when the victim lunged for that pistol. The jury rejected that claim and again convicted the defendant of second-degree murder. So the issue on appeal is whether the trial court abused its discretion or whether some additional remedy was necessary for a Ferguson violation. I'd like to sort of plot this out again because there are people in the room who might not understand exactly what we're talking about. So, due process mandates that defendants have a fundamentally fair trial. And when it comes to the preservation of evidence, there are a couple of steps. There are really 4 steps that this court looks at to determine whether that trial was in fact fair. First, did the state even have a duty to preserve the evidence? Second, if they did have a duty to preserve, did they fail in that duty? Third, if they failed, did that failure somehow result in the defendant not having a fair trial, or would it result in the defendant not having a fair trial? And then if it would result in the defendant not having a fair trial, what is the appropriate remedy to ensure that there is a fair trial? So the first two steps, did the state have a duty to preserve? I think, I know your honors asked questions about public records and things, but I think the trial court found, and it reasonably makes sense, that the state recorded this, had control over it, they probably had a duty to preserve. Second, did the state fail in that duty? I think it's reasonable to say that they did. To your questions about the timeline, I want to make sure we get the facts clear. So the defendant shot and killed his son on April 2nd, 2018. The indictment was returned 4 months later in August. That same month, and to your point, Judge Greenhalgh, my recollection is that the record doesn't include a Rule 16 request from the defense, but it does include a trial court's order for the state to comply with the rules of discovery and turn things over.
Can the trial court require the state to produce evidence under Rule 16 in the absence of the defendant's request?
I'm a little shaky on that, Your Honor.
I mean, for example, let's say that I did not want, as defense counsel, I did not want to disclose my expert. And if the trial court is ordering that the state provide its expert, I have a duty now to disclose what I have.
I think to your Honor's question, the reciprocal duty for a defendant to have to comply with Rule 16 requires that they make the request. Whether the court can order the state to turn things over without imposing any burden on the defendant, I think I'm just not sure about that. But either way, the state complied with that. Again, roughly 4 months after the shooting. Then 3 years went by. And to your Honor's questions, when did the defendant request this or point out, hey, I made a 911 phone call. I've known about this since I made the phone call. He didn't point it out until 3 years and 2 months after that phone call. Just happened to be 2 months after the 3-year destruction or retention policy of the 911 police department.
So if within 4 months of the homicide occurring, the trial court is already ordering the state to produce evidence. When does the state produce the 911 phone calls it's aware of?
The record isn't entirely clear as to that, but I would submit sometime within that same month or just a short while after. There are no complaints. The defendant hasn't said, doesn't file anything saying, I've never received discovery.
So there's not a motion to compel that's been filed?
No, Your Honor. So at some point, pretty early on, the state complies, and then again, the defendant waits 3 years. But if we're looking at the two factors, if we want to just assume for the sake of argument, the state had a duty to preserve.
Why would we presume that, though? Because I'm struggling with that on how this timeline is worked out, and especially considering the fact we're talking about a 911 recording, which, as far as I know, would be a public record, something that's held not necessarily in a law enforcement office, but in a municipal 911 communication center. Why does the law not require the defendant to take some reasonable steps during that time to procure that evidence, especially if it's so critical to the defense as it's been presented?
Well, Your Honors can certainly go ahead and decide on that basis. I can't think of a reason not to. And so if Your Honors wanted to go. The trial court did make that finding, but this court, when reviewing whether the trial was fundamentally fair, which I think these considerations go to, this court reviews it de novo, which means it's a fresh plate. It doesn't matter what the trial court did. This court can make up its own mind. So if this court wanted to determine that there was no duty to preserve put on the state because the defendant could have accessed those records in the 3 years that they were maintained, then the state encourages it to do so. But if it wants to go along and uphold the trial court's findings of a duty to preserve and a failure to do that preservation, then we get to the third problem, which is, did that failure to preserve possibly render the defendant's trial unfair? And there are 3 factors that this court looks at when making that determination. And again, that determination is also on de novo review. So this court, even though the trial court determined that it would have been rendered fundamentally unfair, this court can decide otherwise. And here, the first problem that you look at is the degree of negligence on the state. And to Your Honor's points, that degree of negligence was minimal at best. The state, as my friend on the other side acknowledges, there's no malicious intent here. The state complied with its retention policy, the police had a 3-year retention policy, and the reason that this one got destroyed was simply because the 2 calls didn't get linked. The defendant called 911, Ms. Pearson called 911. When the police responded, each 911 call created its own report incident number. When police responded, they put all their notes and all of their statements and everything on Ms. Pearson's incident number for her phone call. And then the defendants just simply didn't get linked.
So your friend on the other side says, look, we're not arguing that it was intentionally destroyed, and so we don't have the heightened guilty mind here. He suggests, though, that when the trial court found it was negligent not to preserve it, that the negligence could have been simple or gross. And he argues that it was gross negligence because the 911 center is not following its own policies. And so it's not just a simple, hey, we didn't link these at the time. It's we did not follow our policies, and that resulted in the destruction of evidence. Why is it not gross negligence?
So first of all, I think when this court reviews the trial court's comments, even though the court didn't say the degree of negligence was minimal, the context of it makes clear that the court thought it was rather small or minimal negligence. And the reason it's not gross negligence is because there was no conscious action to do this. This simply fell through the cracks. They did not realize they were linked. And in fact, the police department did follow their policies. They retained it for 3 years in accordance with policy and then deleted it in accordance with policy.
Of course, negligence never requires conscious action, right? I mean, if we have conscious action, then we have knowing misconduct. If we have conscious action, we have intentional misconduct. Conscious action is not something we typically think of as gross negligence, is it?
But even with the cases that the defendant cites, when this court has found gross negligence, it effectively is a conscious decision. It's where police had evidence that was used in trial A, and before it got to trial B, they just destroyed it. And they act like they knowingly destroyed it. So
all things being equal, if this court were to find that it was grossly negligent not to link the 911 phone calls so as to preserve them, would that weigh in favor of a remedy different than a jury instruction?
I don't think so, because that's one of the 3 prongs. So even if this court finds that the negligence wasn't minimal and was instead gross, was high, then we go to the other factors. And the second factor is there substitute or secondary evidence? And to your point, Judge Greenholz, there was an abundance of substitute or secondary evidence. There was the CAD card, which made notations of the comments that the defendant had given to the 911 dispatcher. There was also Ms. Pearson's testimony, which is where she came back into the room and heard the defendant say, "I need somebody to come down here. I shot this boy." There's also the defendant's statement to police twice. And first, immediately after police arrive on the scene. And to be clear, I don't think the defendant was cut off. Instead, based on the body cam footage, the officer asks, "Why did you shoot him?" Or, "Why did you shoot him?" The defendant says something that can't be heard, but completes that sentence, and the officer's response is, "Well, you shot him over that." Not shut up, not be quiet. Initially is, "Well, you shot him over that," and that's on page 214 of the record. And then that same night, I want to say it's within an hour or two, but the record will be more accurate. Sometime that same night, he gave a statement to police. And then finally, the substitute evidence we have is the defendant's own testimony at trial. When you have that accumulation of substitute evidence, and when you're weighing that prong, that weighs heavily in favor of finding that the trial remains fair. And then the third prong, when you're just looking at the fairness of the trial, is the substance of the evidence. And the evidence here was overwhelming. Again, all of these comments, the defendant's own actions of going and obtaining the gun. So his claim was that this shotgun was always in the shop, and I just walked next door to grab it. Ms. Pearson said she'd never seen it in the shop. The defendant's own wife testified that the shotgun usually remained in their house in a closet, and then police found a rifled cloth bag out in the parking lot, which indicates the defendant went and secured that weapon before coming to shoot the victim. When the evidence is that overwhelming, all 3 factors we submit weigh against a finding that the trial would have been fundamentally unfair without this 911 phone call.
When we weigh these factors, is there any room in Ferguson for us to consider how this evidence would have been used from an evidentiary standpoint at trial? And what I mean by that, I know Mr. Gill mentioned, he seemed to contend that this was an excited utterance, 911 call. Of course, we're talking about a recording of a statement of the defendant, which you would generally consider as being self-serving hearsay if it was offered by the defense. is it appropriate for us under Ferguson to think about that and think of a hypothetical where the state said, hey, I don't think this is trustworthy, I think it's self-serving, I'm not going to put it in my case in chief, and then what does the defendant do with this evidence had it been preserved?
I think that's certainly a factor for this court to consider. I think it's almost a totality of the circumstances under the third prong of would this have come in, how would it have come in, and then what impact would it have had when you weigh it against everything else. And so I think this court can consider that in determining that this trial was not rendered unfair based on a destruction of that 911 phone call. But even if this court decides that the state did have a duty and that this would have been rendered fundamentally unfair, the trial court properly exercised its discretion in determining what the appropriate remedy is. And when we're looking at what that remedy imposed was, the standard of review changes. So this court is now acting in deference to the trial court. Who's sitting there, who's watching the trial, who's sort of the boots on the ground. This court gives deference to that. And in order for it to overturn that, to say that a different remedy was appropriate, this court has to find that the trial court applied an incorrect legal standard, reached an illogical decision, or that it based its decision on an erroneous assessment of the evidence. The defendant hasn't alleged any of those three here, and the state submits that he can't because the trial court gave a well-reasoned basis for why it was determining that a jury instruction was appropriate. It considered this, and it found that, this trial might be unfair without the 911 call, but dismissal is completely unwarranted and is unnecessary. I believe it called it unreasonable to dismiss the case, and instead it found that a jury instruction was appropriate, and it gave that jury instruction. It told the jury, hey, the state had a duty to preserve, and if you find that they failed to do that, if you find that they did not preserve this 911 phone call, you can consider that it is favorable to the defense, that it bolsters his testimony, that it makes him more credible, that it goes towards his defense. And the jury was told that. We presume they follow these instructions, and they nevertheless found that he was guilty of second-degree murder instead of acting in self-defense. So there are really at least three different ways that this court can affirm the trial, or affirm the judgments, either by finding the state didn't have a duty to preserve, by finding that the failure to preserve did not render the trial fundamentally unfair, or by finding that the trial court acted reasonably, acted within its discretion in determining that a jury instruction was appropriate. I think that's all I have. If this court doesn't have any further questions, we respectfully ask that you affirm the judgments of the court. Thank you.
I think we maybe took a little of Mr. Gill's rebuttal time. How much did he have left, Mr. Whitmer?
3 minutes.
Okay.
Mr. Gill, can I take a little bit more?
Please do. Yeah.
I may give you a little more back. We'll see how that goes.
We can negotiate.
That's right. Interesting hearing your friend's argument on the other side about really what is fundamentally an issue here. Let me posit a hypothetical to you. Let me say that the defendant's 911 phone call was never destroyed. It wasn't linked by the 911 center, but it was never destroyed. It was always preserved. Parties don't ask about it. For whatever reason, Mr. Forte doesn't ask about it. And you go to trial without the 911 phone call. Would that be a fundamentally unfair trial at that point?
Just think about that for a second. What I think distinguishes that hypothetical is that in that situation, even if the phone call is potentially stolen, in that situation, the state has not reached the duty. And so that changes the scenario. That changes the due process equation because the state has not reached its duty to preserve potentially exploratory evidence.
So in that situation where there's simply a failure to link, but the 911 phone call is still preserved, there's no Ferguson issue, or maybe Rule 16 issues, maybe the discovery issue, no Ferguson issue.
In that situation, there are, I think, other doctrines would come into play because at that point, maybe the trial court would consider it continuous because you can still hear your phone call. It's not gone from the face of the earth. And so different considerations come into play when it's still available. And then you really might look at things like the diligence and sequence and so forth.
So even though the trial would be exactly the same, going to trial with exactly the same evidence, the mere fact that the evidence was destroyed and not available as opposed to no one requesting it, you would work different outcomes?
I believe that the Constitution applies differently in that situation Because here we have a constitutional violation. The whole problem here is that the Tennessee Constitution recognizes a stronger due process protection. And that due process protection is the source of the duty to preserve potentially exculpatory evidence. And the trial court found in that finding of due evidence that this evidence was potentially exculpatory. Just like in Marion, where the Tennessee Supreme Court approved dismissal, they said it couldn't have been ruled to the state that it was potentially exculpatory. And therefore, the duty arises not from Rule 16, but from Article 1, Section 8 of the Tennessee Constitution of law of the land. So that supersedes anything Rule 16 has to say about this. And just briefly, Your Honors, on a couple of points, as my time winds down. My friend made a point about the substitute evidence in this case that I'd like to just briefly talk about. First of all, as I mentioned earlier, all of the substitute evidence pertaining to the 911 call was incomplete and conveniently more favorable to the state. That's the problem we saw in the state, which is with the Clark, and we see it here again as well. And as far as the other evidence, his statements to the police and so forth, it was inconclusive and far from overwhelming as to his mental state. It was overwhelming that the killing took place, and you can see that. But when it comes to his mental state, it was not overwhelming. It was inclusive. For that reason, we asked that this court, the first judge of the trial court, dismiss the accused of the trial.
All right, thank you. This case was really well briefed, and I appreciate your good arguments and your patience with all of our questions. We're going to be in recess, and Judge Greenhouse, do you want to let them know how the
Yeah.
question and answer will go?
I think this is a wonderful opportunity, one that candidly doesn't happen if we're in an actual court setting. So you as students have the opportunity to talk with both of these lawyers. They're both excellent, outstanding advocates. Pretty impressive, actually, on both sides. It was a great argument. You have an opportunity to ask them questions, either about the case, you can ask them questions about